Under the Individuals with Disabilities Education Act of 2004 and Maryland Special Education Statutes and Regulations, children with disabilities and their parents are guaranteed procedural safeguards with respect to a free, appropriate public education provided by Anne Arundel County Public Schools. In Maryland, these safeguards are described in the booklet titled Procedural Safeguards, Parental Rights.
Who can be considered a parent?
A parent is defined under IDEA regulations as the biological or adoptive parents of the child, a foster parent unless prohibited by state regulations, a guardian authorized to act as the child's parent or to make educational decisions for the child. Please note, a guardian can never be a state official, such as a Department of Social Services case manager. An individual acting in the place of a biological or adoptive parent, including a grandparent or other relative with who the child lives, or an individual who is legally responsible for the child's welfare. If there is no one who meets the definition of a parent, AACPS will appoint a surrogate parent for the child. AACPS provides training for adults wishing to act as surrogate parents.
Can the school system provide special education services without my consent?
Parental consent is required in order for the school system to conduct assessments and to initiate special education services. Parental consent is not required to implement IEPs developed after the initial IEP. Parents have the right to withdraw consent for special education services. However, parents should consider very carefully whether or not this is in the best interest of their child. As long as a child is receiving special education services through the school system, a parent may access their procedural safeguards to resolve a dispute regarding disagreements over services or placement, or what constitutes a free and appropriate education. Once a parent withdraws consent for services, their child is no longer entitled to those safeguards, including, but not limited to, disciplinary protections, the provision of a free and appropriate education, or any supports above what is provided for students who are not eligible for special education services. Additionally, if parents want to reinstate services if their child is having difficulty, the process is started again from the very beginning with an IEP-A. Therefore, the decision to reinstate services does not occur immediately.
Can the school system change the services provided to my child without letting me know?
AACPS must provide the parent with a written notice before they begin and or change any special education service provided for their child. In Maryland, the IEP document itself can be considered prior written notice. If parents make a request regarding their child's services that the school-based members of the IEP team disagree with, the parent must be provided with written notice that includes the basis for the disagreement, evaluative information on which the decision is based, and other options that have been considered and rejected prior to the beginning of or change in the service.
What if I disagree with the school system's assessment?
If a parent disagrees with an assessment conducted by the school system, the parent may request an independent educational evaluation, or IEE, in writing or at an IEP team meeting. The school system could either agree to fund an independent evaluation at no cost to the parent or initiate a due process hearing to determine if the original assessment was appropriate. If the due process judge decides that the evaluation was appropriate, parents still have the right to an IEE, but not at public expense. Parents always have the right to have their child evaluated by a qualified professional of their choice at their own expense, and the IEP team must consider the information from that evaluation when making any decisions with respect to the education to the child. Keep in mind that AACPS has specific criteria that must be met when we agree to fund an IEE. For more information, contact the school system's Compliance and Legal Issues Office.
Can my child be removed from school for disciplinary problems?
A child with a disability who violates the Code of Conduct may be removed from school for not more than 10 school days in each school year in accordance with the discipline policy used for all children. Specific procedural safeguards applicable only to students receiving special education services must be in place after 10 days of disciplinary removal.
What if the behavioral problem was a result of my child's disability?
Once a child receiving special education services is removed from school for more than 10 cumulative days or recommended for a long-term suspension, a meeting is held to determine if the behavior was a manifestation of the child's disability. At this meeting, the team will consider two questions. Was there a direct and substantial connection between the incident and your child's disability? Was there a direct and substantial connection between the incident and the lack of implementation, if any, of your child's IEP? If the answer to either of these questions is yes, your child will return to school and the disciplinary removal will be over. If the answer to both of the questions is no, your child's disciplinary removal may continue and the IEP team will determine appropriate services. If a student with a disability is recommended for a long-term suspension or has more than 10 cumulative days of suspension in one school year, the IEP team must determine appropriate services that enable the student to progress in the general curriculum and progress on their goals. As with all students, decisions regarding services during a disciplinary removal are based on the student's individual needs.
What if my child was not yet determined to be eligible for special education services?
A child has the same rights as a child receiving special education services if, before the behavior resulting in the disciplinary action occurred, the parents expressed concern in writing that their child needs special education and related services to supervisory or administrative personnel or to one of the child's teachers. The parents requested an evaluation, or the child's teacher or other school personnel have expressed specific concern about a pattern of behavior demonstrated by the child directly to the Director of Special Education or other supervisory personnel. These rights would not be available if the parents refuse to allow AACPS to evaluate their child, the parents refuse to allow AACPS to provide special education services, or the child has been evaluated and it was determined that he or she was not a child with a disability under IDEA.
Can I decide to place my child in a non-public school?
A parent always has the right to do what they think is best for their child. However, if parents choose to place their child in a non-public school without the agreement of the public school system, they do so at their own risk and expense. If the IEP team did not agree on the placement, parents have the right to access their procedural safeguards in order to resolve the dispute.
What is a facilitated IEP team meeting?
A facilitated IEP meeting is conducted by a highly trained volunteer from the Arundel Conflict Resolution Center. The facilitator will keep the discussion focused on the desired outcome and will remain neutral throughout the process. The goal of the facilitated IEP meeting is to help team members communicate effectively and work towards developing an educational program to meet your child's needs. Facilitated meetings are particularly helpful when a parent or team is expecting the discussion at a meeting to be challenging, but may be helpful at any time.
Do educational decision-making rights transfer to my child when he or she reaches the age of 18?
In Maryland, parental rights do not transfer to children with disabilities on reaching the age of majority. They may, however, transfer under limited circumstances if there is documentation that the parents are unavailable or unknown and the student requests that the rights be transferred directly to them. The parents have not participated in the special education decision-making process after repeated attempts. The parents have rejected participation. The parents cannot participate due to hospitalization, institutionalization, serious illness or infirmity, and the parents have consented to the transfer of rights. The parents cannot participate due to extraordinary circumstances and have consented to the transfer of rights. The child is living outside of the parent's home and is not in the care or custody of another agency. If the parent with whom the child resides does not consent to the transfer of rights, either party may file a due process complaint to determine whether rights should be transferred.
What if I disagree with a decision made by the school system?
A parent has 3 methods of resolving a dispute: mediation, a due process hearing, a state complaint. Mediation is a non-adversarial process where the parents and school system attempt to reach consensus on what will resolve the dispute. Both parties are expected to make some concessions in order to reach an agreement. The Office of Administrative Hearings, an independent state agency, provides a mediator to facilitate the process. Mediation agreements are binding and enforceable in court if either party violates the agreement. A due process hearing is a more formal procedure. There is evidence, testimony, and the rendering of a decision from an administrative law judge. AACPS will have an attorney present at a due process hearing. When a parent requests a due process hearing, a resolution session will be held within 15 days. During the resolution session, the parties can gain a better understanding of the concerns and attempt to resolve the complaint. There is no judge at a resolution session, and AACPS will not have an attorney present unless the parents are accompanied by an attorney. If the parties fail to reach an agreement 30 days from the date of the hearing request, the due process timeline begins. The administrative law judge will make a decision within 45 days. The time limit for filing for due process is 2 years from when the party knew or should have known of the problem, with limited exceptions. Parents who feel that the school system violated the procedural requirements of the IDEA may file a complaint with the Maryland State Department of Education, or MSDE. The MSDE will conduct an investigation and determine compliance with state and federal regulations. If the school system is found to be in violation, they will be required to complete student-specific corrections, school-wide corrections, or system-wide corrections, depending on the level of the violation. MSDE must resolve the issue within 60 days from receipt of the complaint, unless an extension is permitted. The time limit for filing a state complaint is 1 year from the date of the alleged violation.
What if I feel my child has been discriminated against?
If a parent alleges that their child has been discriminated against based on their disability as a result of school practice or policy, the parents or the school system may elect to engage in voluntary resolution, for which there is no investigation or finding of a violation. Either party may suggest a course of action that will resolve the dispute voluntarily. The Office of Civil Rights, or OCR, may conduct an investigation. There may be a finding that there was no discriminatory policy or practice, or the school system may be ordered to make corrections. The Office of Civil Rights also offers early complaint resolution, a mediation that resolves the case to both parties' satisfaction. As with the voluntary resolution, there is no investigation or finding of a violation. This overview provides a snapshot of the information in the Procedural Safeguards Parental Rights booklet. For more specific details about your rights as a parent, see the Procedural Safeguards Parental Rights Handbook, available online or from your school, or contact the school system's Legal Compliance Office. For more information, refer to the Anne Arundel County Public Schools Special Education e-Handbook and the Maryland Procedural Handbook, Parents' Rights Handbook.